As I was mentioning in my opening remarks, we have chosen as host a topic that we believe is going to be very interesting because we are all confronted to the judicial review of our decisions. And sometimes it is difficult for us to understand each other, I mean enforcers and judges. So we thought that a dialogue between enforcers and judges would help us understand ourselves, each other better. So let me introduce my fellow panelists today. In my far left, I have Gina Cass-Gottlieb, is the chair of the ACCC, the Australian Competition and Consumer Commission. Close to her is Doris Tsepe, commissioner of the South African Competition Commission. To my far right is Mr. Rodrigo de la Peza López Figueroa, who is a judge from the Specialized Economic Competition, Broadcasting and Telecommunications Tribunal in Mexico with federal jurisdiction. And then to my close right, I have Wenel Muguet-Puleng, who is a referender at the Court of Justice of the European Union. Joining us online, and I thank you very much, Peter, for the very last minute invitation. You are a good friend. Is Mr. Justice Roth, judge in the Chancery Division of the High Court of England and Wales. As you see, I have the enforcers on one side, and then the judges or the judiciary on the other side. And in the judiciary, we have specialized judges, so that's already a plus. And the panel is going to be structured in the following way. I will ask each of the speakers to devote 5 minutes to explain to us in a simple way how the main features of the enforcement/judicial review of competition decisions is done in each jurisdiction so that you have a context and a framework of, to understand it. Then I will ask their forces and later on the judges, which are the main challenges that you are facing when thinking about judicial review of our decisions? Where do we find the problems? So that we can understand which are the problems of each other. And last but not least, if we have the time, I would like to touch upon the topic of private actions, because believe it or not, we, competition authorities, will have a role to play, not only in damages, but also in many of the cases that are now standalone actions before the jurisdictions, and maybe there we have a role as expert witness or something. So we would like to discuss that as well, if time allows. So with no more, I will ask first Doris to start by explaining to us, 5 minutes, how the system of judicial review in South Africa works.
Good morning, everyone. And first, I would like to congratulate Ms. Kani Fernandez, the president of CNMC, for hosting this important event. And secondly, to thank you, Kani, for inviting me on your host panel. Firstly, let me explain that the South African system is an interesting one in that we have a separation both of the administrative, i.e. the investigative, and prosecutorial body. And that body is through the Competition Commission. And that separation is from the specialist adjudicative body, being the competition tribunal. The competition.
Can you put your microphone a little bit down?
A little bit down?
Yeah.
Is that perfect? Is that perfect? Can you hear me? Thank you. So sorry about that. As I said, there is a separation of the administrative and prosecutorial body. That function is performed by the Competition Commission, and that it is separated from the specialist adjudicative body, being the competition tribunal. The implication of this is that the vast majority of decisions of the Competition Commission concern either recommendation to the Competition Tribunal in the case of mergers or referrals to the Competition Tribunal for adjudication in the case of market conduct matters, including both abuse of dominance cases or cartel cases. It is only in respect of intermediate measures, exemptions, and more recently, outcomes of market inquiries that the Commission has decision-making powers. But even in these cases, parties can still review or appeal the decision of the Commission either to the Competition Tribunal or to the specialist courts or the High Court system. Beyond the tribunal, the Commission and parties have rights of appeal to the Specialist Appeal Court, being the Competition Appeal Court. The Competition Appeal Court is a court which comes from the ranks of the High Court. It is specialist in nature in the sense that it only hears competition matters. However, it is filled by judges of the High Court, meaning you do not have specialist judges in, or judges with specialist competition law in those matters. We have been very fortunate in South Africa that the judge presidents of both of the court in the past 2 terms have been judges with specialist knowledge of competition law, being the recently retired Justice Dennis Davis and the newly appointed Justice Manoem, who was the Competition Tribunal chairperson for the longest of time. However, in that court, most of the judges who come through that process would be judges who have been drawn from the ranks of the High Court system without specialist knowledge in competition law. Obviously, that raises, it has both the pros and cons, and we will speak about that when we talk about the challenges and benefits to it. From the Competition Appeal Court, parties do still have a right of appeal to the Constitutional Court. The Constitutional Court, as most of you would know, is the apex court in South Africa, and you can appeal, both the Commission and parties can appeal decisions of either the Competition Tribunal or the Competition Appeal Court in respect of constitutional matters and legal issues of public importance. The Competition Tribunal, being the specialist adjudicative body, is an important body in the judicial review of competition matters. And that is a truly specialist body because members, both full-time and part-time members, have legal expertise. It is currently chaired by Ms. Mondo Mazwai, who is a lawyer by training, but in fact, most of the members of the Competition Tribunal are economists, and that has helped a lot in respect of cases. As I've said, most of our cases have to be heard before the tribunal, which has decision-making powers, and we have to provide evidence, specialist and expert evidence of economic nature.
We will discuss that of economic evidence later on.
Yes, so that is what that is the nature of our judicial review structure in broad terms.
Thank you very much, Doris. Gina.
Thank you, Connie.
I think we have prepared some very short slides in order to illustrate you. If you can, if the slide of ACCC Australia can be projected so that the audience is able to see it at the time. Thank you so much.
First, congratulations, Connie. It's
welcome.
Just superb. And thank you for inviting me to participate in this dialogue with the judges. You can see on the slide, Australia is quite a useful example, I think, for this panel because we have a combination of a prosecutorial model.
I see people doing like this. Try to put the microphone as closer to your mouth as possible, sorry.
It's okay. Is that better? I'll hold it there in that case. So I think Australia is a very useful example for the purposes of this panel. In most cases, we have a prosecutorial model, which for you, I think will be on the left-hand side, referring to judicial process. So this is in relation to our investigation and then enforcement. The ACCC is the prosecutor that takes to our federal courts in respect of civil matters. In respect of criminal, we refer it to a director of public prosecutions to make a decision as to whether they will take forward criminal charges. The decision is then made in the federal court structure. The federal court is a generalist court, though at times we certainly do have judges who have had a participation through their work at the bar in relation to competition matters, but it is a generalist court. When we look on the right-hand side, this is where the ACCC has an administrative decision-making power. This is in relation to our power to grant exemption from the application of our Act, both to anti-competitive conduct and to mergers. And we are able to do so in respect of substantial lessening of competition contraventions, either on the basis that we're satisfied there's no likely substantial lessening of competition, or where it is a per se contravention, such as cartel conduct, on the basis that there is a net public benefit. So a public benefit that outweighs the anti-competitive detriment. We have granted such in situations, for example, of product stewardship schemes, circular economy proposals, where industry comes together and is best able to achieve those benefits through coordinated action. In those matters, it is a judicial review, a review process. However, it's important to note it is a full merits review. So a specialised tribunal in this case with a presiding judge that generally has competition law experience, accompanied by an economist and a lay expert who has experience in the relevant industry, comprise the tribunal, and they have the full capacity to determine themselves and on what terms authorisation is either granted or not granted. There is then a judicial review process from their decision, if parties wish to take it, to the federal court on the basis of traditional judicial review bases, so error of law. So we happen to have, and ultimately, a matter can go to our highest court, the High Court of Australia, but only with special leave. So if it concerns a question which is of particular note for the whole of our legal system. So we have both a prosecutorial model and an administrative model.
Thank you so much, Gina. Now we are going to have a framework of the judicial review system in Europe. If you are kind enough to project the slide of the European Union, we will have the framework.
So may I wait for the slide? Or?
Yeah, we are trying to project the slide of the European Court of Justice and the European Review. Here we are. Next one. Okay, thank you.
Yes, thank you so much. Thank you, Kenny, and thank you as well for the very kind invitation. I am delighted and very honored to speak with my fellow panelists and in front of such an audience. I must say as well that I'm a bit surprised to be here because I'm not a very good speaker. I'm much more a writer, so please forgive me for a lot of things, including my English. So I would like to describe the main features of the EU judicial review, and I would like to use one word. It's a duality, because in Europe, we are trying to work together, and in doing so, we are used to find some imaginative solution. So first, I think it's very useful to note that we have two tracks in Europe to have some kind of judicial review before the Court of Justice of the European Union, which acts as a Supreme Court on EU law. The first track, which is very, very useful and interesting in practice, is decentralized enforcement. So with the 27 member states and the NCAs, with the help of national courts, we have this possibility via preliminary ruling of sending in a question to the European Court in order to have an answer on a point of interpretation of EU law. For instance, in some cases like Generics UK or Towercast, we have some very, very interesting answers from the European Court of Justice that are useful for the enforcement of competition law within Europe. The second track is the usual tracks. It's through centralized enforcement. So first, of course, the Commission is both designing the rules and investigating and deciding on cases relating to cartel abuse on one side and merger on the other side. When the decision is enacted, the appellant has the possibility to have a judicial review before the General Court first, the judge of first instance, via an action for annulment, and then later on appeals on point of law before the Court of Justice, the Supreme Court. That's the first point, the two tracks. My second point is to emphasize the fact that judicial review has different meanings in the EU. It depends really on the case at hand. On the one side, you've got cartel and abuse. So the question here is the accused, and I'm using the word not undertaking, but accused, is the accused guilty beyond reasonable doubt? So for us, at least for me, and of course I'm giving my personal view, it's more like a quasi-criminal case, and we have some cases from the European Court of Justice. I'm mentioning Infineon, a recent case, where the Court of Justice emphasized the need to have an in-depth review of all the elements of the decision in light, of course, of the pleas and evidence submitted by the parties. In some instances, when we are dealing with a fine, the General Court may substitute its own appreciation, its own appraisal to the one made by the Commission. So we have a good example here in the recent Google Android case before the General Court. In merger, on the other hand, the question is more here to look for is a significant impediment of effective competition is more likely than not. That's the test. Here it's an administrative case, and we are focusing on an assessment of the evidence provided by the Commission in order to demonstrate the plausibility of its prospective analysis. So here I'm mentioning a recent case of the European Court of Justice, Sika Telecom, and as an example, the case of General Court in Ryanair Aer Lingus takeover. And my third and final point would be to, just as a general note, to say that both meanings are evolving, because it's really a matter of, we've got cases that are focusing on what was named by a famous former member of the General Court, Jan Forrester, in a famous article entitled "A Bush in a Need of Pruning, the Luxuriant Growth of Light Judicial Review." So in the past, for many practitioners, you had this perception that the EU General Courts were a bit shy. I mean, for many private practitioners, they argued that the decision of the Commission imposing penalties are not subject to a full merit standard of review. And judicial review was a source of disappointment, especially compared to the judge they are accustomed to meet in the USA, the UK, or in some member states like France or Germany. So they tend to view the EU courts as being shy, a little bit shy. But I don't think that's the case anymore, especially in Infineon or CK Telecom. So my personal view would be that we are now in a position to be able to ensure effective judicial protection. That would be my point later.
Thank you very much, Renel. We're going now to the UK. You mentioned that we were, the legal profession was criticizing a little bit the judicial review of the courts of justice, and they were putting the UK system as a model or as example. So now let's go to hear what Mr. Justice Roth has to explain to us on how the judicial control of competition decisions in the UK work. Please, if you are kind enough to project the slide, we have a slide with a schematic presentation of how the system in the UK works. And then I will ask Justice Roth to explain to us.
Good morning from London. I hope you can hear me. Perhaps, Kenny, you can nod. Thank you. I'm only sorry that I cannot be with you in person in the beautiful city of Barcelona, but thank you very much for including me all the same in this distinguished panel. The UK system as it is today was essentially established some 25 years ago at a time when the UK was, of course, a member of the European Union. And we followed the EU model for public enforcement. That is to say, we have an administrative model. Our National Competition Authority, which as you all know is the CMA, carries out the investigation and takes the decision, whether it's on merger control or antitrust. And in antitrust, the CMA can impose significant financial penalties for violations. So it takes a full decision itself. And then we have a number of sectoral regulators for telecoms, water, energy, and so on. And they have parallel jurisdiction for competition law and operate in the same way. Each of these is a national UK body. I stress that because it's often forgotten that the United Kingdom comprises 3 jurisdictions. England and Wales is one, but then there is Scotland, and thirdly, Northern Ireland. Then appeals against any decision of the CMA or the regulators go to a specialist competition court, the Competition Appeal Tribunal, or as it's often called, the CAT. That is a UK tribunal, and it's a multidisciplinary tribunal. It has a judge as the chair and 2 other members drawn from a panel which includes lawyers, people from industry and the public sector, and most notably economists. And if we have the slide, you see the CMA and the sectoral regulators, the appeal going to the CAT, but then from the CAT there is a further possible appeal, but only on a point of law or against the level of penalty. And that will go according to which jurisdiction it is. If it's a Scottish case, it goes to the Court of Session in Scotland. If it's an English or Welsh case, it goes to the Court of Appeal in London. If it's a Northern Irish case, it goes to the Court of Appeal of Northern Ireland in Belfast. And from there, but only with permission, there is the possibility of an ultimate appeal to our highest court, the UK Supreme Court. So that's fairly straightforward, but I should stress that the CAT is not only an appellate tribunal. Despite its name, it's now also a court of first instance for private competition claims. So a claim for damages for violation of antitrust law can be either started in the CAT or transferred to the CAT, and a lot of the CAT's work now, in fact, is private claims. There's one other aspect of the UK regime that I'll mention very quickly, and that is this: alongside financial penalties or fines on the business or company, there is the possibility for sanctions on individuals. And if we could please have the second slide, where I've set out the 2 types of sanction. Criminal penalties, that is the cartel offence, for individuals implicated in a hardcore antitrust infringement. You see the nature of the involvement that's concerned. It gets a lot of publicity, but so far there have been very few prosecutions. Perhaps partly because this is a full criminal prosecution, goes to the criminal court, and under the British system that involves trial by jury. The second kind of sanction is used much more frequently, and that is directors' disqualification. There's a special provision in our law for disqualification for competition law involvement. That's obtained by an application to the court, so it's not a decision of the CMA, it's an application that it makes to the court decides and can make an order. It's done, as I say, quite frequently. It's much easier to obtain. The burden of proof is the civil burden, the civil standard, not the criminal standard. And the maximum period of disqualification is 15 years. So that's proved quite an effective measure against individual directors. And you see from the way the law is written on the slide, the sort of involvement that the director had to have to justify disqualification, including in subsection 6(c), he did not know, but ought to have known, that the conduct of the undertaking constituted a breach. And that, I think, is my 5 minutes. Thank you.
Thank you. Thank you very much, Justice Roth. Now we go to a different jurisdiction, Mexico. Please, when you can, project the slide, and I will give the floor to Rodrigo de la Peza so that he can explain to us, well, there are some differences in the amparo and things like that in Mexico, so please go ahead. Yeah.
Thank you. I would like to thank you, Moderator Candy Fernandez, President of NMCC in Spain, and for inviting me to this annual conference of the ICN. And all the panelists, it's an honor to be here and share this panel with you. I apologize if my English is a little rusty. I thank you for your patience. As for the first question, in Mexico we have two constitutionally recognized, financially and politically independent autonomous organisms working as antitrust regulatory agencies. The Federal Economic Competition Commission, COFECE, and the Federal Institute of Telecommunications, or IFETEL, with a vast regulatory function that implies the power to issue highly specialized regulation adjacent or complementary to antitrust federal Congress laws. So this has led to some challenges regarding the determination of a clear line between both legislative and regulatory competencies. The Mexican antitrust system includes criminal and administrative enforcement, as well as judicial review. So let's start with the administrative enforcement. The vast regulatory function of the antitrust agencies also implies an investigative and decision-making powers, which allow them to implement an administrative enforcement, both ex ante and ex post. Some of the procedures to prevent a future or ongoing transgression to economic competence, that is ex ante, include, for instance, merger notification and pre-approval by the agencies, who can establish conditions to reduce harm risks. Another one is a benefit of the minimum fine or a reduced fine granted to the economic agent who comes forward with information that is useful to determine, stop, and sanction an anti-competitive practice. Another ex-ante procedure is a procedure where the agency issues an opinion regarding the granting of a license or concession about the conditions of a particular market, or a formal general opinion about some aspects of economic competition. Ex post, both regulatory agencies can conduct an investigation and, based upon its findings, hold a trial-like process to apply sanctions to agents committing anti-competitive conduct, that is, monopolistic practices or unlawful concentrations. In these proceedings, agencies can impose different kinds of sanctions, normally fines, but they can also impose some other enforcement measures, like the director's disqualification, or in cases of relapse in serious transgressions, The agency can duplicate the fine or even order the disincorporation of an economic agent through alienation of their assets or their shares or stock. Furthermore, the criminal enforcement. Absolute monopolistic practices, such as collusive practices, economic cartels, are criminally prosecuted, as long as there is an accusation from COFECE or IFETEL with a report of probable responsibility therefrom. The criminal proceedings and the administrative procedures can coexist, and a person can be held responsible on both levels. This has risen some questions about the non bis in idem principle, or the prohibition of double jeopardy, and the principle of res judicata, or finality, that a decision taken in either of the criminal or administrative proceedings may have with regards to the other. Further, a person can avoid criminal prosecution or responsibility by applying for the benefit of the minimum fine or reduced fine that I talked about earlier. An ongoing criminal procedure can also be cancelled on an agency's request when the defendant complies with the administrative sanction. And last, the judicial review process. In a trial-like administrative procedure, the agencies have full jurisdictional faculties, and their decisions are final and equal to judiciary sentences. Nonetheless, all definitive acts and decisions of the regulatory agencies, as well as the law of Congress regarding economic competition, can be challenged through a juicio de amparo, that is constitutional procedure, before the federal courts specialized in antitrust, law, broadcasting, and telecommunications. These are courts of one judge. And the amparo was originally designed to put the state through any of its organs, bodies, or officers and employees from any of the three branches on trial for violations of human rights. A sentence reached in a juicio de amparo can be appealed before the collegiate specialized courts, and when it contains a decision regarding the constitutionality of a law, before the Supreme Court of Justice. Thus, an amparo filed against a sentence issued by the agencies, or a law of Congress, or the agency's technical regulation, is a procedure to determine their constitutionality and their compliance with human rights. Now, a discussion has come up as to whether economic competition can be recognized as a human right. It hardly can, but the courts have regarded it more as a constitutional principle that generates obligations of the state, which can be instrumental for the fulfillment of other human rights, like the right to an adequate living standard or the freedom of commerce. I think that...
Thank you very much, Rodrigo. Let's go to the challenges now, and I will ask Gina to explain to us, maximum 4 minutes, the challenges that judicial review poses in your jurisdiction or for the authority, both from a procedural and from a substantial point of view.
Thank you, Kani. So, as you would have seen from the left-hand side of the previous slide, in the case of almost all competition law enforcement in Australia, the ACCC role is as the prosecutor, the decision as to whether there has been a contravention, and then what the sanctions are to be is a court decision. So our capacity to both achieve effective sanctions to remedy harm and deterrence to seek to deter future conduct is dependent upon our success in convincing the court both as to liability and the appropriate sanction. This raises a number of challenges. So firstly, sanctions there include penalties, remedial orders, injunctions, future conduct orders. So looking at the question of pecuniary penalties, it is absolutely critical that pecuniary penalties are at a level which are not solely a cost of doing business, but actually create deterrence and cause large corporations, frequently with very significant resources and sophistication legally, to take it into account in relation to future conduct. We had an experience for many years in the construction industry and construction materials industry of successful prosecutions but continued conduct. Our legislature has recently increased penalties to $50 million per contravention. There can be multiple contraventions in repeated conduct, or 3 times the harm, or 30% of the turnover. We do not achieve anywhere near those levels in the penalties that are determined by our courts. We consider that we are not currently achieving penalties at a level which creates sufficient incentive for deterrence. It's interesting because our court applies a principle of that the penalty strikes a reasonable balance between deterrence and oppressive severity. As enforcers, we recognise the due process element relating to oppressive severity. We just think that the courts need to take very clear attention of the capacity, size and extent of harm, particularly where we have widespread systemic harm, and need therefore to weigh on the side of deterrence in that balance between oppressive severity and deterrence, because if we do not achieve penalties at these levels, the public will not have confidence in ex post enforcement, and the public will look to and the political sphere will look to other means, including more ex ante framework. The procedural concerns we have, Kani, are firstly that these proceedings in court, particularly when they are sophisticated deep pockets defendants, take a long time, over a decade in our prosecution of 12 airline companies in relation to price fixing conduct, for instance. In that period of time, in a fast-moving industry, much of these 3 days we'll talk about digital platforms, much harm will have occurred in 10 years without a remedy. And similarly, we have the problem that there is a lot of dynamic change occurring, which our court judgments necessarily are confined to the facts and the specific matters and evidence we put before the court, and therefore don't address widespread across industry concern. And this is the fundamental reason we have felt that this judicial model does not serve us sufficiently, and why we have advocated and recommended ex ante regulation for digital platforms in Australia.
Thank you very much, Ina. It's really interesting. Doris.
Thank you. I think as I explained, we have to, I just want to make sure that everyone can hear me. Because we have to refer all matters to the competition tribunal, that necessity of prosecuting before the tribunal or all courts major prohibition or conduct cases has led to a more resource and time-intensive process than you would in a purely administrative system. What it means is that contested proceedings involving use of lawyers, senior lawyers, factual and expert witnesses, and this has cost implication for the Commission. I mean, roughly a quarter of the Commission budget is allocated to the cost of litigation in the system. Parties predominantly contest to see if any body, the tribunal or the courts, will reach a different view to that of the Commission, and have sought to hire top lawyers and experts, foreign experts, given that there is high stakes on acquisition matters or penalty for contravention. In the case of conduct cases where parties are in no rush to conclude their matters, process also permits parties to raise procedural issues to delay the process, often appealing, as Gina has said, on procedural aspects of the Competition Appeal Court. We have had matters where prosecution has taken to the upwards of 9 years to finalize those matters. This has led to a significant increase, in fact, in interim relief applications that are now coming before the Competition Tribunal by affected parties, while the more extensive process of prosecution is continuing. In measure control, the parties have an incentive to move proceedings along very quickly, but the process posed challenges for factual witnesses called by the Commission, as competitors or customers are often unwilling to appear against merging parties before the tribunal, or harassed through demands for discovery for their own information. The relatively low cost of appeal to the Competition Appeal Court, in that it is on papers and requires very little time to appear before the tribunal, before the Competition Appeal Court, has resulted in parties failing at the tribunal, typically appealing their decision to the Competition Appeal Court. This, as I've said, has knock-on effect both from a time and a cost perspective, as the Commission is then required to defend these cases as they are appealed through the courts, either the Competition Appeal Court or, in some instances, to the Constitutional Court. While the system has considerable short-term costs and challenges, there are numerous longer-term benefits for the system. And first, it has forced the Commission to raise its own internal standard of investigation and decision-making. This is because there is an expectation that any prohibition of a measure or any referral of a conduct case will be contested, and the evidence gathered in the investigation will be tested before the courts. This has resulted in the Commission developing its own expertise, either through economic division, where we have our principal economists routinely appearing as experts in the court. That division supports any complex measure or conduct cases investigation that is likely to be had before the tribunal or the courts. Similarly, we have created a specialist legal services division that exists to handle prosecution, either alone or through use of counsel in larger matters. The other benefit, which I think is perhaps a more important one in relation to the role of the courts, is that outcomes from cases, especially those that are appealed to the Competition Appeal Court or the Constitutional Court, establish legal precedent, which greatly assists the Commission in future matters. This is because parties will now know or be aware of the views of the courts, which itself seeks to create consistent legal cases, legal precedent. And this is what I refer to as a coherent establishment of a jurisprudential framework. And this helps both the Commission in some of the cases that it takes, but it also helps parties to know what cases to do. A typical example here would have been the work of the Commission and the courts during the COVID-19 pandemic, where the Commission took two price gouging cases which they prosecuted successfully before the Competition Tribunal. What then happened is that you had 35 settlements that subsequently came through. So while there is short-term challenges on development of jurisprudence, in our view, there is a long-term benefit which provide a solid foundation to guide future decisions of the Commission, but also to promote compliance by companies as they seek to adhere to the law. The Commission now deliberately seeks to find cases to take through the courts in order to establish that jurisprudence and promote compliance or adjust existing behavior by parties. This applies equally to matters of strictly competition matters, but also that have constitutional relevance, as we have seen in the recent Constitutional Court judgment in the Mediclinic matter, where the Constitutional Court has made it clear that when we interpret the Competition Act, it must be interpreted in line with the Constitution of the Republic of South Africa. I think I'll end here in the interest of time.
Thank you, Larissa. Gwenel, tell us, which are the main challenges that the courts experience when dealing with competition cases?
Yes. For me...
Focus on the main problems, because we are going...
of course.
out of time.
Sorry. So only for me 3 points. The first one, of course, is extremely important. Say how to be time effective. I mean, that's a challenge for everyone here. And I want to be short because most of the time the main criticism is results are there, but remains disappointing. I think that's could be a good line. Ex post enforcement takes time, but I think it allows punishments and it allows public and private enforcement, but sometimes we are lacking the means to intervene on time. I think the NCAs here are much more effective I think the European Commission recently has tried to do some, with the Broadcom case, to reintroduce the need to intervene on time. But this allowed me to open another door, another box, that's the DMA, the Digital Market Act. I think that's a way to answer the problem, a very specific problem with gatekeepers, in digital markets. So there is this imaginative way to find an answer. So the DMA, briefly, because we could speak at length on this, I think it's a fantastic tool, but it's as well a paradise for lawyers, because it's a complete reversal of what I tried to explain in my opening statement, that, case-by-case analysis and effective judicial protection. Here, we are working on a paradigm. It's a change of paradigm. You are a gatekeeper. You have a list of obligations. You need to comply. So we will see in the near future, but it's a way to answer the problem in a time-effective way. That, for me, is the biggest challenge of our time. The second point for us, I think, with working for enforcer or for the court, it's a quality issue. It's the quality issue. So I think, speaking of the concepts, currently we know everything is stabilized, burden of proof, standard of proof, and I think I see in the case law, I see in the practice a lot of good things, so we can now focus on the case and trying to give effective judicial protection to the undertaking or to the accused. And so that's the point of evidence. We are going to speak on evidence later. And the final point, that for the enforcer, it's just to focus on building your case. So what are the concepts? What are the facts? Where is the evidence? For us, at the court, it's very useful to be precise, to know what is what. And from time to time, I see a little bit of schizophrenia from the enforcers. As an example, speaking of market definition, market could be this, but it could also be this. And if it's this, there is no problem. The same for effects. Effects, of course, they can be potential, they can be likely, but if I'm able to give some actual effects evidence, it could be better for the punishment. If there is actual evidence of an effect, then the punishment could be higher. A good example is Android, for instance. And under appeal, of course, from Google. And my last point, for speaking from someone working within the General Court, is focus on quality on our side as well. So a little bit less of what I name as a tunnel of quotes from past case law. I mean, we should focus on the case and give an answer to the case at hand. That could be very useful. Focus on quality from our side as well. And as an example of beneficial interaction, because I think it's very important to remember that we are all working together, I would just give an example of, where there is a dialogue between the Commission, the courts, and the private parties. It's the example of an ecosystem, for instance. In Android, we try to refine the concept of market definition. Long gone are the days where the Commission, it was proposed to the Commission to distinguish banana from fruits. Now, we are in the reality now. So we introduce a notion of ecosystem, meaning that if you have a boxing match between people and who is the winner, who is going to be the repeated winners, that's an abuse of dominance, you may ask the question, and that was tackled in generics, of someone coming from the outside to box the winner. That's the catch situation in generics, the potential entries in the coming features. And then with the ecosystem, you need to focus on the public and ask yourself, is the public about to leave the match and to go elsewhere? For instance, to leave the Android stadium to go to the Apple Arena, I don't know. That could be an issue. So ecosystem was a notion that was introduced in the economics 20 years ago, that was introduced in the practice 10 years ago, and now the time was ripe for maybe the General Court to introduce some rules, some principle, obvious principle, and then the Commission is going to maybe implement them in the current guidelines that is currently drafted. some quick thoughts on the...
Thank you, Werner. Thank you very much. I'm going to Justice Roth. I know that you will have a hearing soon, so you will have to leave us soon. So please go on the challenges, and Rodrigo, if you don't mind, I will ask you later on.
Of course.
Peter.
Yes, thank you. People talk about the common law, family of nations, but listening to Doris and Gina, I think my perspective is very different from what you would hear if you had a South African judge or an Australian judge, because we, of course, start a hearing appeal with a full decision of the competition authority, including its decision as to penalty. Looking at challenges, I think one needs to distinguish fundamentally between the position on a merger case and the position on an antitrust case. For mergers, an appeal is by way of what we call judicial review, and that expression has a very technical meaning under UK public law. It is not a full appeal. It's a challenge in part to the decision-making process, rather than the question of whether the decision was right or wrong. There is some degree of overlap, because one ground of judicial review is that the decision maker failed to have regard to a relevant factor. And you can imagine that well-resourced parties sometimes try and smuggle into judicial review what is really a challenge on the merits, but we are very alert to that and resist it. It also means that save in the most exceptional cases, on a judicial review of a merger, the CAT will not have any new evidence placed before it or any expert evidence. In general, the tribunal looks at the evidence which was before the authority at the time the decision was taken. The last speaker referred to the problem of time. On merger cases, I think we generally seek to decide them quickly, within 1 to 2 months. On antitrust, the position is really completely different. That is, under our statute law, a full appeal on the merits. The burden is on the CMA to justify its decision, and the CAT will hear evidence, including live witnesses, and sometimes extensive economic evidence. There are 2 reasons for this difference which are, I think, important. First, that the finding of an infringement of the antitrust provisions, usually accompanied by a large fine, is classified as quasi-criminal under the human rights provisions which apply in the UK, that is the European Convention on Human Rights. Remember, we may have left the EU, we are still in Europe. And for a criminal case, therefore, an undertaking has the right to a full hearing before an independent judicial body, and the CMA is obviously not a judicial body, nor is it independent, because it is, as I said earlier, it's making the investigation and taking the decision. So the CAT is the first judicial body before which the case comes. And secondly, under UK competition law, as now I think under EU competition law and that of many states, a finding of infringement by our authority is binding in a subsequent damages claim. That's part of the policy, of course, of wanting to facilitate victims obtaining a compensation. They don't have to prove the breach all over again. But if the civil court is going to be bound by the finding of the authority's decision, and the defendant would have no right to challenge all those findings when they're sued for damages, well, that would be unsustainable. And so the quid pro quo, as it were, is that they have the full right to challenge the decision on an appeal before the CAT. And those appeals can be complex. It's not a rehearing of the case, because the appellant will usually confine their appeal to certain specific grounds and not challenge every aspect of the decision. And the appeal, of course, focuses on those grounds. But we will have, as I said, economic evidence, and that is a challenge for judges like me who are not economists and indeed never studied economics. it's much easier for the CAT, of course, because as a multidisciplinary tribunal, where a case involves significant economic evidence, there will be an economist on the panel deciding the case. But we still, all of us, have to understand and scrutinize the economic evidence. The question arises, what deference should we give as judges to the view of the CMA and the decision? On, again, the distinction between judicial review, where of course the decision on the merit stands, and infringement, but even within infringement appeals, on the question of infringement and interpretation of the law, I think very little deference. It's a full appeal. In distinction, when it comes to the penalty, the CMA, like many authorities, has guidelines as to the appropriate amount of the penalty, and that comprises the usual factors you're all familiar with: the duration of the infringement, the amount of sales or turnover or commerce that's affected, the seriousness of the infringement, aggravating, mitigating factors, and so on. Well, if it's a question of the duration of the infringement or the value of commerce, those seem to me hard-edged questions, and the decision is either right or wrong, and we would look into that. But if it's a question of seriousness, that's rather more subjective, and I think in practice we do pay deference and accord a margin of appreciation to the CMA. If we didn't, then really many of these large defendants would just appeal because they would give them a chance for another go and see if you get a different view of seriousness, and everyone would appeal their penalty, which is not what happens. And yes, there on antitrust cases there can be problems of duration. I think one has to look at this question of duration end to end, from the start of the investigation to the end of the appeal, and I think there are problems that can arise at both levels: the duration of the NCA investigation, which has to be assessed alongside the duration of the appeal process. Thank you.
Thank you very much. Rodrigo, from your point of view, the challenges of reviewing decisions from the competition authority.
Thank you. Well, standard of proof, that is one of the main challenges for the judicial review, because it involves determining which standard the agencies have to use when they are assessing evidence. And this can be very confusing for judges, because as lawyers, we'd like to answer firstly and plainly which facts have to be proven, especially since the Supreme Court has established that in sanction proceedings, some modulated principles from criminal law must apply. So the facts must be proven. But the thing is, well, for instance, a frequent complaint in the amparos is that the authority didn't really prove the damages allegedly caused in the market to a certain amount. This is, in some cases, it's not even true. The agencies do calculate an amount of damages normally equivalent to the illicit profit gained by the anti-competitive practice. But the thing is, it doesn't really or necessarily work like that, because according to the law, harm is one of the elements taken into account to evaluate the severity of the transgression. And in general, the proof of all these elements in interrelation demonstrate the existence of an anti-competitive practice and the elements required to calculate the sanction. So it's a different way to look at facts. Well, there are some parameters in our legal system that make the judge's task a little easier. For example, the anti-competitive behaviors are described specifically in the law in different grades of severity. And for each grade, the lawmaker has already set a minimum and maximum quantity of the fine. For example, a percentage of the agent's annual turnover. So in a way, the Federal Congress has already established a legal presumption of damage for each of the grades conforming the scale. This has a practical advantage that if the agency can't prove the harm, it can nevertheless impose, in some cases, the fine at its minimal rate, depending on the legal grade of transgression. In this subject, the courts have distinguished between some practices that have to be proven unreasonable to be punishable, and that harm has to be proven too, whereas some other monopolistic practices are always illegal per se. So the proof of its reasonability or its effects on the market are not always essential. Second, according to the Supreme Court, the agencies may establish their own methodology of assessment, in general and in every case in particular. So if they establish a reasonable methodology previously explained and they regularly use it for all cases of the same sort, the standard of proof is higher for the plaintiff in the amparo because they have to prove that this methodology is wrong or illegal or inconvenient. Third, the courts have developed some series of indicators that can prove, presumably, some anti-competitive practices, like the existence of a relevant market of homogeneous or relevantly related products, the existence of few producers with relatively high market power, the existence of associations or chambers of commerce that can be used as platforms for collusion, the existence of communication or supervision mechanisms to survey compliance with the collusion agreements, etc. The courts have also established a so-called holistic methodology of assessment based on the logical increase of credibility of both facts and their evidence when confronting them one in front of another in an orderly or even chronologically fashion. So if the evidence is presented in a formally clear and transparent way, the decision will be harder to challenge. But otherwise, on the contrary, if it's not, it will be very easy to declare void or illegal. With the weight of procedural issues versus substantive issues in judicial review, I would like to say, well, this relates to what I just said. An advantage of procedural judicial review is that it does not require a reevaluation of economic, technical, or scientific evidence, not in all cases, so as to determine if the decision is valid. It requires only that the evidence was evaluated in a way consistent to the detail with every procedural requirement established in the law and regulation. This because of the legal procedural, if the legal procedural requirements are adequate, the conformity thereof reduces the probability that the evidence was evaluated incorrectly, because those procedures, for example, an impact assessment, are designed precisely to ensure the right methodology and processing of information and to minimize arbitrary or ill-intended decisions. But a disadvantage may be that the procedural review could only produce a weak argument to invalidate the law or the regulatory decision. Depending on the level of judicial scrutiny, some procedural violations may be regarded as less important than the democratic or political value of Congress legislation or the discretional regulatory powers of a highly specialized agency. On the other hand, a substantive judicial review can expose a human rights violation or an arbitrary or unreasonable decision, creating a powerful argument for the invalidation of the law or regulatory decision. It can also open a subject to public debate based on information produced by experts, which may impulse a more legitimized lawmaking and regulation. These are the advantages. A main disadvantage, of course, of the substantive review is that it may open the door to an excessive judicial intervention.
Well, thank you so much. I think we could continue discussing this topic for a long time, and I would ask Andreas to maybe organize a workshop or something where we could go into more detail. And there are many topics that we wanted to discuss: how to tackle economic evidence, how to help courts in standalone actions, for example. But coffee is waiting, and I don't want you to hate me. So I think I'm going to wrap it up. Please thank our speakers, and let's go to coffee break.